Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and above the Commonwealth. I'm going to give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. So I see we already have the parties for the case, our first case on our list for the courtroom arguments today. We've already heard one case on Zoom, already seated. I'll call the case for the record, which is Commonwealth versus David Woodley, number 2022-0518. I'm just going to remind the parties briefly that you have 15 minutes to present your argument, and there is no rebuttal in the appeals court. And I'd also like to introduce the panel to you. To my right is Justice Mary Sullivan. To my left is Justice Sabita Singh, and my name is Ariane Buno. So, Attorney DeMaio, please begin.
Good morning. May it please the court. Christopher DeMaio for David Woodley. There are two issues. The first one, the sufficiency of the evidence. I don't plan to talk about a whole lot because a picture is worth 1,000 words, and the panel has the video and kind of see what the issues are from the video. One point I do want to make, though, is that the decision was for Judge Harrington to make, and the Lattimore decision is for this panel to make based on the video itself, because the Commonwealth's brief, the trial transcript, and then the Commonwealth's brief has a lot about officer so-and-so thought he saw a gun, and trooper so-and-so thought he saw a stiff-armed gait, which was consistent. That would be appropriate if there was no video, and sometimes that kind of evidence does come in. But there is a video, so the judges, Judge Harrington and this panel are in as good a position as the officers to say what is what. And for what it's worth, I think some of that was kind of exaggerated. There's talk about stiff arm. I mean, Mr. Woodley is rattling dice and rolling dice and hopping around on one foot with one shoe. So I thought that was...
Well, we do have the video.
Yeah, you have the video. So unless there's any further questions on the Lattimore issue, I'm going to talk about why the conviction should be reversed if we lose the Lattimore.
I'll just ask one housekeeping question. You do agree that we have the authority to view the video ourselves and make a decision regarding the sufficiency of the evidence based on our review?
Yes.
Okay.
Yes. All right. So the second issue is the authentication of the video. The video is obviously the key exhibit at trial, I guess, besides the gun. So if it came in erroneously, it would be certainly prejudicial, I would submit. It was admitted around pages 29 to 30 of the transcript over objection. I want to be clear, there's kind of two parts to the video issue, so to be clear, there's the video system itself. So there's a camera somewhere in New Bedford that's transmitting this data to a police station a mile or two away, and the police officers are viewing it on a screen and to some degree controlling the camera remotely. And then the second part of that is there's some kind of computer system which allows them to replay it, because they talk about replaying it on video, and apparently allows them to record it because we have this DVD which came from somewhere. So I'm not conceding either of those two parts. The second part, I will say, Officer Oliveira did testify that when he watched the video at trial, it looked like, when he watched Exhibit 1, he said it looks like what I saw on the screen because of the angle and so forth. Not conceding that the CD came in properly, because there's really no evidence about how it was created and where it came from and who made it and so forth, but Isn't
that fairly obvious from looking at the video itself, where it came from and who made it and who is it? I mean, the police officers were also depicted in the video.
I mean, according to this court in the Connolly case, you're supposed to have some kind of I mean, I guess you could always say it's obvious in authentication cases. It's a video, you know. It's my
just being obvious. I agree with you. Is not the end of the inquiry. Yeah. But
I don't know that it is obvious. I mean, he didn't say he made. I don't know where it came from. I don't know when it was created. There's just not a whole. The whole key to this point comes on pages 28 to 30 of the transcript, and I submit if you look there, there's really nothing much there. So we're not conceding that about the DVD and whether that was a proper video exhibit to come in. But on the first part, the video system, there was completely, I would submit nothing other than that there's a camera somewhere on this corner of New Bedford and the police can see it back in their station. This was over repeated objections by defense counsel. So again, prejudicial error. There's three ways.
Counsel, what was the nature of the objection, though? I read the objection to be that the keeper of the record wasn't there.
I mean, I took it as a general objection that it's hard to, I mean, the judge kind of cut him off and said, your objection's noted, and also part of it, I believe, was inaudible for a few seconds. So it's not entirely, he did mention the keeper of the records, but then he renewed his objection after the officer had testified that this was appeared to be what he saw that day. So I take it as an objection to everything. And he says, I don't know where this came from. Could have been a more fulsome objection, but the judge again kind of cut him off and said your objection's noted, and I'm taking it over your objection. This court and the SJC have said there's three ways to authenticate a video. So the first is to have somebody say that's a fair and accurate view of what I saw that day. That didn't happen here because Oliveira wasn't there. He was back in the police station. The second is to have...
But he did testify that he saw the video at that time.
He testified that he saw the video at that time.
At the
yes.
police station.
Yes. But I'm talking about to authenticate it, you have to tie it to the actual physical site, which he wasn't there. So he was in a position to say, yes, this CD that we're watching in court looks a lot like what I saw on the screen, but somebody has to tie it to the real world, which would be, I guess, the other officer, St. Germain, who testified later and was the one who actually went there. The second way you can authenticate, according to this court in Conley, is have someone testify to surveillance procedures and the methods used to store and reproduce the videos. I would submit we just didn't have that here if you read pages 28 to 30. And the third method, which the Commonwealth talks about in their brief, in which the SJC discussed in the Davis case a couple years ago, is to have circumstantial evidence. And I take this to be kind of, I think the first and third theories are kind of the same. If you have enough circumstantial evidence that it's fairly and accurately depicts the scene, then you can kind of use that in lieu of having a witness say this fairly and accurately depicts the scene. In Davis, you had plentiful circumstantial evidence. You had a police witness, a civilian witness. You had photos from various angles that had been independently authenticated and corroborated and suggested that this video was a real thing. Here, the first point, I guess I want to draw the court's attention, this is a preserved objection, and the person who actually, according to the Commonwealth, laid the foundation is St. Germain. He didn't testify till later, so I mean, if this were sufficiency of the evidence, if this were substantial risk, you might say, well, he should have taken it to Bene and then admitted it later, and no big deal. But this was over objection. But the second point I want to make is this just wasn't really plentiful circumstantial evidence like you saw in the Davis case. This was, it was Officer St. Germain said, I went there, yeah, I found this guy, it's Mr. Woodley, he identified him, and there was a truck. But it's very thin, assuming the court would consider that after the fact. So we would submit that was not properly authenticated. The judge was on notice of the objection. It's really kind of a matter of principle now. Mr. Woodley's already served his time, so I guess the principle is just that when it's a serious crime, firearm is an 18-month mandatory minimum, so things are done a little bit more expediently in district court sometimes, but when you have a case like this where there were objections and it was brought to the judge's attention and it came in, I would submit that if the court rules for the Commonwealth on the Lattimore, that there should be a new trial, and if the Commonwealth wants to retry him, so be it, but those are the points we wanted to make today.
Okay. I see no additional questions. I just want to assure you and your client that whether or not the time has already been served, we take the case just as seriously as if he was still serving it or had to serve it. So you
Certainly.
can assure him not to worry about that.
Certainly, yeah.
Okay.
Thank you.
Commonwealth?
Good morning, may it please the court. Alicia Sanchez for the Commonwealth. We ask that the court affirm the conviction of possession of a firearm without a license. I'll follow the order of my brother and briefly first address sufficiency. Here, there is sufficient evidence to support the element of possession. First, the video depicted the defendant with what appeared to be a white-handled firearm in his waistband. 12 minutes later, the defendant is depicted taking something out of his waistband and placing it into the open truck bed of a white Dodge Ram. 3 minutes later, that the police locate a white-handled firearm in that same location, the open truck bed of a white Dodge Ram. I would argue that that's sufficient to prove possession here. As to authentication, the judge did not err in admitting the surveillance video because it was properly admitted by circumstantial evidence. Here, Officer Oliveira testified that this was a police camera that was pointed at Ruth and McGurk Street. It was there for the purpose of police safety and officer safety. Public safety and officer safety. The officer testified he was able to zoom in and out and control the camera as he did that morning. And he testified that he recognized that video as being the video that he watched live that morning. And he knew this based on the angle, the location, the date, and the timestamp on the video. Furthermore, the Officer Oliveira sent officers to the scene, and in the video you see officers arriving at the scene. This was more than sufficient for a fact finder to find that this was what the proponent claimed it to be, which was a surveillance video pointed at the scene that morning that he watched live. And the defendant needs to prove abuse of discretion here, which he can't because St. Germain later testified that he confirmed what was seen in the video was what he witnessed in person at the scene. So if there are any questions, I'll ask the court to affirm the conviction.
I'll confer the panel, and I see no questions. I think everything was explained very well in both briefs, and so we understand all the points. Thank you both very much. We'll take the case under advisement and get an answer back to you as soon as we can.
Thank you.
Thank you. The next case we have before us is Commonwealth versus Winston Waite, and if I've mispronounced the defendant's last name, I expect that you will correct me. Case number 2022-0500. Good morning, Attorney Maddox.
Good morning, Your Honors. My name is John Maddox for the defendant Winston Waite. Before I get started, I just want to mention a recent Rule 23 case. It's not exactly on point, but it is a corroborational case. It's Commonwealth versus Jassy, J-A-S-S-E.
Well, could you go just a little slower for me, please?
Sure.
Commonwealth versus, yeah?
J-A-S-S-E, Jassy. It's 102 Appeals Court 1107. It's a Rule 23 case. It doesn't involve a statement as to the driver. The actual statement was the person was doing the defendant was doing the field sobriety test, and he said, "I couldn't do this if I were sober," and so they pointed out that they distinguished Leonard by noting that there were a number of observations by the police regarding lack of sobriety.
Okay.
This is a corroborational case involving ambiguity as to the identification of the driver. There are two key factors in the totality of the circumstances that suggest that there was insufficient corroboration. One is that there was no evidence as to possession of the keys. That's on Volume 1, pages 143 to 144. Trooper Hayes was asked if he recalled where the keys were, and he could not. He noted that they were not in his police report either. So that's one factor making it similar to the Leonard scenario, where there was a struggle over the keys in the front seat of the car, where the wife was sitting on the husband's lap, so it was unclear which of those two were the drivers. Similarly here, we have Mr. Waite outside of the car with a female companion. So this is a scenario where there are two possible drivers. If you look, there are 6 factors. One, the two people being outside of the car. The second being the lack of evidence as to possession of the key. And in that regard, I would distinguish the case from the Lombard case, that the defendant had the keys in his pocket, and the Robitor case where the defendant gave the keys to the police officer. There's a couple of other factors that make this similar to Leonard, which was reversed for ambiguity as to the identification of the driver. One is that the seat positions were not checked to see if they matched up to Mr. Waite's height or to the height of the female companion. I'm not sure, I don't have the page cite on that, but
That's all right. I mean, isn't the big difference between this case and Leonard that in Leonard, the second person, the wife, said, "I was driving"?
well,
And in this case, you have, no one volunteers that, and he agreed to do field sobriety tests, which would suggest that he thought he was driving, because why would a passenger do a field sobriety test?
Well, the ambiguity as to the wife's testimony versus her statement at the scene in Leonard was that at trial, she testified to say that she was the driver. At the scene, she I believe, said that the husband was the driver, or at least did not make a similar statement that she was the driver. So there was inconsistent statements.
Well, and he had inconsistent statements in Leonard as well, but that's kind of my point, which is, isn't this case a lot different? He says, "I was driving, no one else claims they were driving." He's not inconsistent, and he performs the sobriety tests. Under Adams, I think Adams is the case to distinguish.
Okay, in regard to the wife's testimony, it's true that she's making express statements, and the female companion of Wade is not making statements of any kind either way. To me, that's similar in that you don't have a statement that is clear cut that the defendant is the driver. So one is express, one is
But
like,
do we require direct evidence? Don't we usually permit
well, it's
the Commonwealth to satisfy the Lattimore standard with circumstantial evidence?
I suppose, but here it's a totality of the circumstances test. You take the factors as a whole, give them whatever weight you deem is appropriate. So I would suggest that in Leonard, you have the inconsistent statements from the wife. Here you have no statement one way or the other. To me, that's very similar, where you don't have the in regard to the weight that you would give the statement or the lack of a statement by a third party. In regard to the field sobriety test, you mentioned the Adams case. There are 4 cases mentioned in my brief: Manning, O'Connor, Adams, and Eggsware. They all involve field sobriety tests. All of them have stronger pro-Commonwealth factors if you're weighing the totality of the circumstances here. In 2 of those cases, there was a sole driver. So it wasn't a Leonard 2-person scenario. I believe that was Manning and Eggsware. Eggsware was the one where they followed him home. So it's not a scenario where there's ambiguity as to the identification of the driver. In the other 2, O'Connor and Adams, those are 2-car accident cases. In one, there was a group of people, bystanders outside, who identified the defendant as the driver. So that's a stronger pro-Commonwealth scenario than we have here. We don't have that. Similarly, in Adams that you mentioned, the operator of the second vehicle identified the operator of the first vehicle as the defendant. So we have that statement that came in. I'm suggesting that when you look at that factor, even though it tends to be pro-Commonwealth, I mean, Mr. Waite submitted to the field sobriety test, but I would suggest that the other cases are stronger. Also, the trooper testified that he's had experience with people covering for the other person who is the real driver. So that's his testimony, that's Trooper Hayes' testimony. That indeed could be what's going on here, where the statement by Mr. Waite that he's the driver could be a covering for his female companion. If you were doing that, he'd be taking the field sobriety test as well. So I don't think that lends too much. The other factor, the remaining factor, is the further statement that he swerved to avoid an animal. I want to apologize to the panel for failing to cite the Galensky case, which the Commonwealth cited in their brief. I missed it. It was in footnote 4. It's a 128 case, instructive, not controlling. But also in that case,
you don't have to worry about not citing a 128 or a Rule 23. That's okay.
Okay. Well, in that case, it was a stronger pro-Commonwealth case in the sense that Ms. Galensky in that case also stated that she swerved to avoid a construction barrel. That construction barrel was there to be seen by the police officer, so he could literally physically confirm that statement. This, in Mr. Waite's statement that he had swerved to avoid an animal, the animal's long gone. There's no way that the officer could confirm that one way or the other. So I would suggest that it's not as strong as Galensky. Also, it falls into the general idea of statements suggesting he's covering. So I would suggest that we have a legitimate Leonard fact pattern here. If you weigh those 6 factors that I just mentioned, I would ask you to reverse on a Leonard rationale. I'd like to move on to my second argument, if I may. Mr. Waite also contends that there was a substantial risk due to the lack of a Gallagher dissent jury instruction. The Gallagher dissent says...
Ask for the instruction?
It was not. It's substantial risk. I can go through the 4 factors.
Isn't there also, you have to first show there's error, and isn't there also just a general rule that judges do not have to give instructions sua sponte? I mean, how do we say there's error? How do we say there's an abuse of discretion?
I think it still falls under the substantial risk standard of review, Your Honor, and I would ask you to look at the...
That's only if we find that there was error, and Gallagher's a dissent, and there's no request. So how do we say it was error for a judge not to give an instruction that no one asked for?
Well...
That's not a required, it's not a reasonable doubt instruction, right?
It's not a... I would just suggest that it's a correct statement of the law, I believe, that it's, the officer's opinion is a lay opinion. It's not an expert opinion based on specialized knowledge. So I think it's a correct statement of the law, first of all. That's the first part of a Randolph analysis for substantial risk. I think that is a correct statement of law. I think it could be prejudicial here to Mr. Waite, where it was a close case, and there was a distinct possibility that the jury could have given undue deference to Trooper Hayes' opinion as to Mr. Waite's performance on the field sobriety tests. That could have been, outcome determinative in this case. So I think it's a correct statement of law. It's implicit in the sense that the failure to give that correct statement of law in where it matters is an error.
So
And
I just have the following observation, and you can respond or not. But I always, at least speaking for myself, I approach these arguments regarding a sua sponte instruction with caution, because if judges do that a lot, the concern is that they run the risk of interfering with the defense's theory of the case and theory of the defense.
Well,
It's a be careful what you ask for argument in some ways.
sure. I don't think there's a reasonable tactical rationale for not requesting the instruction. The defense attorney talked about the walk and turn test and the one-legged test in his closing argument. That's not inconsistent with requesting this kind of a jury instruction, pointing out that the trooper's opinion, could in fact be wrong. And there's testimony. The trooper testified that a certain percentage of people flunk tests even though they are not impaired. So there's a danger to that. I think there's a danger in according undue deference to the trooper's opinion. If I could move on to another issue.
Still have a couple minutes. Go ahead.
In closing argument, the Commonwealth urged the jury to try the walk and turn test in the jury room. There's the Beauchamp case says you're not supposed to encourage the jury to conduct experiments in the jury room. In that case, it was a murder case involving a dent in a wall. And he said, you try putting a dent in the wall. Apparently that was a rhetorical suggestion. But in this case, it wasn't. It was telling them the walk and turn test isn't as hard as the defense attorney just told you in his closing. You guys try it, and it's not that hard to do. That's inappropriate. One reason it is improper is that they're doing it, in the middle of the afternoon with lights on a flat floor. Mr. Waite's doing it barefoot on an imaginary line in the middle of the night on a highway. So it's not the same, and it could, and it's not evidence either. Unless there are any other questions, I'd like to rely on my brief. Thank you, Your Honors.
Yep, we're all set. No further. Thank you very much for your argument. Commonwealth? Attorney Kennedy?
Good morning. May it please the Court, Nathaniel Kennedy for the Commonwealth, asking you to affirm the defendant's conviction for OUI first offense. I'm going to begin today with issue number 3. Counsel just ended with that. That's the prosecutor's closing argument and the concern that her statement, and I'll read verbatim from the transcript. She states, so he does the 9-step walk and turn, and we saw defense counsel during cross. I have a little bit of trouble. You guys can try it in the back of the room. It's very simple. You have to walk in a straight line. And I suggest to you, if someone can't walk in a straight line without being imbalanced, that's from this transcript, or not taking 9 steps, ask yourself, can this person safely drive a vehicle? So as I point out in my brief, the very passing comment, try it, we know that is frowned upon from the Beauchamp case. It's not good to encourage the jury to try their own experiments. However, that's not the crux of her argument. That's not the crux of her closing argument. And as I say, the 2016 Di Benedetto case, the prosecutor's primary point was not centered around the improper comment, but was instead focused on more forceful points. And what we have here are the more forceful points of her argument, which include the actual indications of intoxication and how the defendant was unsafe to operate a motor vehicle. That included, 1, that the defendant crashed his vehicle, hitting a curb, that he had admitted to drinking earlier in the day, that his eyes were bloodshot and glassy, he had slurred speech, there was an odor of alcohol, he didn't know what time it was, and also there was evidence that he had blood in his system based on the .07 breath test. So that was all in evidence, and those were the more forceful points that the prosecutor was relying on to show impairment, to show that the defendant couldn't safely operate a motor vehicle. So where counsel properly identified the Beauchamp case, it's the suggestion to make your own inquiry to the jury is error, it's frowned upon. However, rhetorical comments are not likely to induce the jury to actually do
Well, but do you really think this was rhetorical? It's not like go put your fist through the wall. It's a little different.
I disagree. I think that it's where you had the object in Beauchamp, and he's saying, look at the shape. You can smash it against the wall yourself. I do think it's consistent with a rhetorical comment, particularly because she says, we saw defense counsel during cross. There's some implication there that defense counsel, it's obviously not reflected in the transcript, was doing something during cross that was consistent with needing to be rebutted. And that is, it's not that hard to do if you're sober or if you're not intoxicated.
That kind of gets to the point that's a little tricky in this case, I think, which is, was the statement, try it yourself, an appeal to common sense or common experience, or was it a request to perform an experiment? Have you found any cases that talk about how you draw that line?
No, but I do think it's the former, not the latter. Obviously, that's much. Yes, I do. Surprisingly enough, I think it's the former. But I do think it is where we work in the
Because the conditions are not the same.
Because the conditions are not the same. That's exactly right.
That may be the divide.
And ultimately, what we are relying on here is that it is a prejudicial error standard, and ultimately, would there be any difference? No, we have significant evidence of intoxication, impairment, and an inability to operate a motor vehicle. So I wanted to start there, kind of moving backwards through the arguments into issue number 2, the failure to instruct on the lay opinion. I'm not going to go very far into that. I agree with Your Honor. There's no error here. There's no requirement that any instruction be given as to an expert versus a lay opinion in this instance. The judge gave the proper Canty instruction that the jury was to weigh the evidence and give such weight as they think it deserves, whether or not the...
Is there any reason not to give the instruction if it's requested?
Well, one, it wasn't requested, obviously, so that's not what we have here. But I do think there's a problem with the instruction, because I think what you have when there's no expertise that's been given, you're essentially asking the jury to be more questioning of a layperson's opinion. And where in OUI context, the courts have always determined that a layperson's opinion is appropriate. We all have a kind of common understanding of what intoxication from alcohol is.
I would agree with you, but I understand the requested instruction to be a reminder that this is lay opinion and not expert opinion. Because, the officer gets on the stand, that gives all his or her just training and experience, is a long description of the FSTs. If you haven't read Canty, and I suspect most jurors haven't, the issue is, do they know it's a lay opinion? Or do they think they're getting an expert opinion?
Well, I don't believe in this context that they do believe that they were getting an expert opinion. They understood, because the trooper testified to what his training and experience was and to what this was being offered for. So I don't believe that they were in any impression that this was going to be somehow an expertise that they were relying on, some scientific background. The percentage comment was made during cross-examination. That was brought out by defense counsel. So the Commonwealth wasn't offering this witness for any further expertise than his lay opinion of intoxication. But I did want to make one comment. If you were to have found that there was error in not giving a sua sponte jury instruction, the fourth prong of the substantial risk analysis is whether counsel's failure to object was tactical. And in this case, where you have a split in the only 2 field sobriety tests that were given, there was the 9-step walk and turn and the one-legged stand, it's very reasonable that the defendants wouldn't have requested such an instruction, because they also were relying on the trooper's testimony for the one-legged stand being indicative of sobriety or intoxication. So there's very likely a tactical decision here why they would not have asked for that instruction in this case. So notwithstanding the fact that it's not error, I think even going through the substantial risk analysis, they would not be reversible error. To issue number 1, whether the operation admission was properly corroborated or sufficiently corroborated in evidence, going through, obviously, we have the corroboration rule, because you can't have a crime in a vacuum. Someone has to have, there has to be some corroborative evidence that a crime was actually committed. And proof of operation in an OUI context may entirely rest on circumstantial evidence. The cases that I cite, we obviously have to go through the Leonard prism here. And as the court pointed out, that case is very different, where the wife was seen struggling with the keys on scene with the defendant and then testified at trial, no, I was the operator of the vehicle. The Galensky case that I do cite, and I know it's an unpublished decision, but it gives a very nice discussion of all our cases of OUI corroboration. So that's Leonard, Manning, Adams, Boothby, and interestingly enough, I think the facts of the Galensky case are extremely similar. It's the defendant indicating they swerved to avoid an animal on the road, and then a crash occurred. And then the testimony is that the circumstances and the scene were consistent with how the crash occurred. That's exactly what we have here. The defendant said, I swerved to avoid an animal, and he hit the curb. When the trooper arrives on scene, he sees that the vehicle damage is consistent with what the defendant told him, that he crashed into the curb, avoiding an animal. So the Adams case, as was pointed out, the fact that another person is present at the scene is unsupported by any other evidence leading to suggest that that person may have been operating the vehicle, cannot serve to undermine the probative value of the corroborative evidence. And the corroborative evidence here, as I said, was the accident scene similar to as the defendant had described it himself as he operated the vehicle. Galensky also says that this is different than Leonard because of how the husband and wife were interacting and then her testimony at trial. And well, as I said, I think that goes through a pretty nice discussion of each of our corroborative cases for what is appropriate corroboration of an admission in these circumstances. Additionally, I'm sorry, that was where my point was going. We have his acquiescence to field sobriety tests that show further beyond the accident as it occurred, that he was the operator of the vehicle. And then lastly, I'll be moving on to issue number 4. We didn't get into this in counsel's argument. However, the denial of replaying audio from the trial during closing, the standard of review is an abuse of discretion. There's no prohibition against playing audio, but if there's an objection, then the judge's discretion to allow that or to deny that.
Were you able to find a case involving audio recordings versus transcript?
No, I wasn't. And so that's both counsel and I, we equate it to the verbatim reading.
Is there any reason not to equate the two?
To not equate the two, no. I think that they're very similar in nature. The only time that there would be maybe some issue is the time it would take to have a transcript generated versus FTR being slightly more available. That would be maybe the only difference. However, I think we're equating the cases as they exist as verbatim readings of transcripts that are available to be read across during closing
What about
argument.
testimony that's particularly emotional or combative or fraught in some way? I mean, the reading of a cold transcript is quite different than playing the testimony, say, of a victim in an assault case.
That may be true.
But not here.
We're not here, and I'm not necessarily advocating for playing FTR recordings that have just happened in a trial, but I don't really have a position. It's within the discretion of the judge. And in this case, I also cite to another unpublished decision that discusses what should we look at, well, length of trial, and then whether or not the major point that's trying to be emphasized is something of credibility or whether it's some deep technical point. And I think that does make some sense when, say, you have a chemist on the stand talking about some complicated, blood or DNA or something like that, and a jury may want to hear that again, and that may be something that is okay to read to them or have them hear again. But when it goes strictly to the credibility of a witness or to the weight of the testimony that they want to give to a witness's particular, the weight that they want to give to the witness's testimony, I think it's inappropriate. In these circumstances, particularly in a short one-day trial, one witness, the jury is presumed to have been able to pay attention to that one witness and then recall what that witness had testified to. This point here that the defendant was trying to make also was somewhat of a collateral issue. The trooper testified, yes, he had an accent, yes, I could understand him, but he also has slurred speech. So that I don't think was there was no appropriate need to replay the FTR for the jury. If we have no other questions on any issue,
I don't believe so. I see no, thank you very
Thank you
much.
very
Thank you
much.
both very much for your briefs and your argument today. We'll take the case under advisement. All right, the next case on our list is Darian Gotzendaner, and I'm going to need some help making sure that I pronounce that name correctly, versus Paul Tressler, case number 2022-0226.
If it may please the court, Bruce Green on behalf of Mr. Gotzendanner, who is here today. This is I'm going to call it an unusual case, different than any I've ever handled, and there's regulations that have been promulgated by the parole board, which I'm going to suggest were not followed in this case, for several reasons, but 303.17 paragraph 2 requires them to conduct a final parole revocation hearing on the first date of parole eligibility for his intervening sentence. And that didn't happen in this case. In 2008, this court remanded the case for a modified order, and that never happened. And I'm not in a position to tell you whether it was the Department of Correction, the parole board, or somebody else, but that court's order got ignored for a 10-year period of time, and there wasn't a final revocation hearing until 2019. So at a final revocation hearing, it's a two-part proceeding. One is to determine whether there is a violation, and the second part is to determine what to do. Given that my client had been convicted of another crime, I'm not going to belabor the point to say the question of violation would have been a strong one, but the question of what to do would certainly be an issue. When I say what to do, the parole board would have two options, at least. One would be to revoke his parole, and the other would be to re-parole him. And in a case where somebody's serving a sentence, re-parole him means allow him to serve the time concurrently with the intervening sentence. And that didn't happen in this case. Now, I know the hearing judge said that he was not prejudiced. Now, when it comes to prejudice, it's our position that the deprivation of this final revocation hearing was the deprivation of constitutional right. And if that's the case, then the burden of showing there was no prejudice would be on the parole board. And I know the parole board relies on the case of Greenholz to say that this is not a constitutional right. But Greenholz is a very different case in that there were inmates that were seeking to be paroled, and the reverse is the case here, where Mr. Gotzendanner was out on parole, and this was a revocation hearing. So all the protections afforded under Morrissey versus Brewer would be applicable to this case. Most importantly, a hearing in a reasonable amount of time. And I know that the parole board relies on the Moody case to say that it's okay for a parole board or the parole commission, as it was in Moody, to wait until the expiration of the intervening sentence and then conduct the final hearing. And I would suggest Moody is very different than this case. Number one, only 3 years had elapsed for the defendant in Moody before he was going to be before the parole board. And there's no federal equivalent of Rule 303.17 that required the parole board to conduct a hearing earlier than that. And the other key difference in that is that the parole commission in Moody had the option at the end of the intervening sentence to essentially allow him to go back and serve concurrent time with the sentence that had just ended. And that's not an option here in this case.
Could I just ask you, at this point, what would you be seeking if we understood your point and we're in agreement? What remedy are you seeking?
Well, the remedy would be to terminate his parole, to end the sentence. So my position is that he was prejudiced, and even if we don't consider this to be a constitutional case, I know the parole board cited cases where there was significant delay in some cases, and the court said that there was no prejudice. The difference is, in each of those cases, the delay didn't change any event that happened. There was a 5-year delay in a child custody case, but the trial still happened. There was a 4-month delay in a judge issuing a ruling, but he did issue the ruling. All of the defendant's appellate rights were still there. All the same things happened. In this case, that's not true. The final revocation hearing that was supposed to happen in 2008 and perhaps each year after that, those never happened.
But it did eventually happen.
Yes, it did happen, but
And your client did not request or or refused to participate in any hearings prior to that. Is that right?
The hearings that did happen in 2008, he did not go to the hearings. However, keep in mind that he did ask his institutional parole officer about whether this would be addressed, and the response was that he was already done with this sentence. So I think holding him accountable for not participating in a hearing that, as far as he knew, wasn't going to take place, and I think that's supported because the parole board's position is that they didn't even know about any of this, so they certainly weren't going to be addressing this. But as I said before, it's a two-part hearing, the first part being revocation, so that the only real issue in any of these hearings would have been whether he was going to be re-paroled or not.
So if I may follow that to its conclusion, because the other piece of your argument here is Slavka.
Yes.
As I understand it, your claim is that he's serving more time than he would have served had he received a violation hearing immediately after the appeals court decision. Is that your argument, or that he should have received a violation hearing even a decade earlier than that, or both?
Well,
Which hearing date do your claims of prejudice turn on?
well, I would say that he's been prejudiced either way. Had this court not done anything in 2008, he would have been finished.
Right. But we did.
Yes.
But we did. And there's no claim that that is improper, that that decision itself is improper, right?
That's correct.
So
But-
doesn't that mean that the fact that he didn't get a hearing in the 1990s, doesn't that kind of make that claim go away? If we take the 2008 decision as valid, there was no appeal from it, it was never heard by the SJC, we don't do collateral attacks.
I actually do make an argument, the fourth argument in my brief, that it wasn't properly decided.
But do we,
Putting that aside for the
putting
moment.
that aside,
He served 4 years on this case, almost to the day, from February of '93 to February of '97 was 4 years. He was served a warrant on this case in February 28th of 2019. 4 years from that will be 3 weeks from now. I know that the parole board...
that 4 years was set aside and recalibrated. So unless you can say that he has as I understand the community parole supervision for life cases and the illegal sentence cases like Slavka, if I'm pronouncing that correctly, and I'm probably not, you need to show that he was serving, as a result of the configuration of events, that he has served more time than he would have.
Well, I think that's clear because...
Based on the 2008 decision and hearing, or the hearing that never...
That was 10 years late.
Right, that was 10 years late.
Well, I'm not sure I understand your question, but based on the...
There's a lot of moving dates in this.
Yes.
And
No.
there's the pre-2008 period, there's the decision in '08,
Yeah.
and there's the hearing that gets held 10 years late.
So I'm saying because he didn't get his hearing in 2008, he may have been released 4 years ago.
He may have,
Because-
excuse me? He may have, I didn't hear exactly what you said. He may have,
He may have been released 4 years ago.
Because you think there was a chance that he would have been re-paroled and the sentences would have been concurrent? Is that
Yes.
the argument?
Yes.
Okay.
But that was really the one issue that would have been present in those hearings that didn't happen.
Counsel for the Commonwealth has said in its brief that that argument is incorrect. Do you have anything you want to say in response to the red brief in this case?
I'm not sure I understand that.
Well, there's a counter-argument that he isn't doing more time.
Well, I think that he is. And as I said before, he served 4 years on this case previously, and now he's serving almost 6. And I realize that they have explanations, that there's labels for different dates. To me,
Will you agree that he received credit for those 4 years when he started serving the intervening sentence, right?
Yes.
Okay.
Well, the start date on the intervening sentence was moved back that period of time.
Right, so he had, I know we can use different terms, but let me say it in lay terms, he received credit for those 4 years. He didn't serve 4 years and then serve the whole intervening sentence. The time that he had already served was credited towards the intervening sentence.
Well, I'm going to couch it differently. The start date for his intervening sentence moved back such that it moved back to the correct point in time.
Okay.
But when he did serve that sentence, he served 4 years. Like I
Again,
said,
4
almost
years
to the
less
day.
on the next sentence that he
And
was
that
supposed to be
was
serving.
Almost 4 years ago. For February 28th of this month will be 4 years. So that was 4 years that he served on this case previously, and now it's turning into something much longer than that. So I have two arguments. One is that that's just fundamentally unfair, and under the waiver argument, the second argument in my brief, a sentence, a parole needs to be pursued with reasonable diligence. And in this case, if you take the Commonwealth as a whole, between the Department of Correction or the parole board, there's no way it can be said that that was pursued with diligence. That was 10 years that this court's order was just ignored. And I know I don't have any case law on that point because I think it's a pretty unusual situation where anybody ignores this court's order like that. But if he did have those hearings and he was re-paroled and served that time concurrently, he would have been released 4 years ago. So I know we can't go back in time on that. But certainly the 4 years that he served is up.
In terms of your prejudice argument, in addition, I know you're saying that the prejudice is the lost opportunity.
Yes.
Is it not your burden to show that that's a reasonable possibility in these circumstances to get that concurrent sentence?
Well, my first answer to that is that if this is a constitutional right, it's not my burden, it's the parole board's burden. But even if it is my burden, it's the opportunity to be heard and address that. And again, this wasn't delayed. I mean, it was delayed in 2019. He did have a final revocation hearing. But again, the only issue was whether you'll be re-paroled and be allowed to serve this concurrently. So to wait until after that opportunity exists and go, hey, here you go, here's your hearing, after any possibility of getting benefit from it is really not a substitute for having done what the regulations promulgated by the parole board require them to do. So if there's no further questions, I'll rest.
Okay.
Thank you.
I see none. Thank you very much.
Good morning. May it please the court. Nicole Nixon on behalf of the respondent, the parole board. I'd just like to make clear one thing for your honors, because I think that this might be the crux of the whole case, and that's the assertion that there was an increase in the reformatory sentence here. I just want to make clear that the 2008 Massachusetts Appeals Court decision and nothing that the parole board did or allegedly didn't do increased the length of the reformatory sentence.
When you say the length of the reformatory sentence, can I say that, I'm going to call it the first sentence? Is that, okay, just wanted, okay, because that's the Concord sentence, right? All right.
Yes,
all
that's
right.
correct. And just for purposes of this argument, I'll be referring to that Concord sentence as the reformatory sentence.
Reformatory sentence, okay.
And then that second sentence that he picked up when he was out on parole as the intervening sentence. So the 2008 Massachusetts Appeals Court decision merely reversed the sequence in which the petitioner would serve those sentences. And once that happened, the 4 years that he had already served on that reformatory sentence was then credited to the intervening sentence. Any good credits or anything like that he got on that reformatory sentence was credited to the intervening sentence. So he didn't lose anything by virtue of the reversal of the sequence of the sentences. And I think that for that reason, The Solovka claim fails. I think there's another reason why that claim fails, which is it's essentially an attack on the 2008 Massachusetts Appeals Court decision, which habeas corpus is not a proper vehicle to do that. But even if you get past that, where there was no additional punishment imposed here, Solovka just doesn't apply, and there's been no double jeopardy violation.
Could you remind me whether or not the second sentencing judge said anything about the relationship between the second sentence and the first sentence?
So I believe that the second sentencing judge did say something, and he made it clear that the sentences were not to be served concurrently, rather they were to be served from and after.
That was my memory as well. Does that not address the concern that had he received his hearing earlier, would reparole have been an option for the parole board, given that statement by the second sentencing judge?
Your Honor, I think that's exactly right. I don't think that reparole, or I guess if you want to take counsel's position that he would have served those sentences concurrently, I don't think that would have been an option for the parole board. And even if it was, I think it's a speculative option at best. And I believe it's speculative to the point, and I believe the speculative nature of that point is borne out by the fact that the parole board didn't do that at the final revocation hearing that was actually held in 2020.
Is the parole board at liberty to reparole somebody under those circumstances if there's I honestly don't know the answer to this question because it's the interrelationship between two branches of government.
I think that's a tricky question, Your Honor. I haven't found any law, Massachusetts law, to suggest, what the parole board has discretion to do when a sentencing judge has made it clear that the sentences should be served from and after. I think where we do have that situation where the sentencing judge did make that clear in his sentencing determination, there would be a definite question as to whether the parole board could even do that in these circumstances. I think also if you look at Moody v. Daggett as well as Commonwealth v. Collins, those cases both make clear that there's no right to serve sentences concurrently. And I think that also weighs against the prejudice analysis in this case. And if there's no further questions as to the other arguments, I just rely on the arguments I've made in my brief and ask that the Superior Court decision dismissing the habeas corpus petition be affirmed.
I see no further questions, so thank you very much. Thank you both very much for your arguments. We'll take the case under advisement. All right. The next case involves the Department of Children and Families versus Mother and Another. I remind everybody that this case is impounded, so please be careful and use pseudonyms for all the parties' names. The number of the case is 2022-0763. And before we begin, I'm just going to double check. I understand that the appellees are splitting their time equally, 7.5 and 7.5?
Yes, Your Honor.
Okay, thank you. Good morning.
Good morning. Members of the panel, may it please the court. Nicole Paquin, on behalf of the appellant mother, who is asking you to remand this matter to the juvenile court on the issue of post-termination and post-adoption visitation.
I was just going to ask you to do that, but our co-officer was clairvoyant. Thank you.
Thank you. Contrary to the appellee's arguments, the issue is properly before you today. As to the merits of the appeal, the trial court's findings do not deserve the usual deference because the principal findings do not align with the evidence and are internally inconsistent. Therefore, they're clearly erroneous. In
Can
addition,
I just ask you about the issue of it being before us today? You do agree that it wasn't raised below and that your client was not at trial. So the issue of post-termination visitation was not raised by your client at trial. Is that fair to say?
that's correct. It was
So
not raised.
your view is that it was addressed by the judge. It's something the judge has to consider. We should look at it in any event?
Correct. Because it's part of the judge's equitable powers, the judge is always able to address post-termination and post-adoption visitation. Therefore, since all parties are on notice that the judge could address it, there's no reason for my client to have raised it below. And therefore, it's properly before the court today.
And we are to assume that your client's position at trial would have been the same as the position that she's advancing on appeal.
Yes, Your Honor. Moving to the merits of the matter, a judge's findings are entitled to great deference when they are specific and demonstrate that close attention has been paid to the evidence. When the judge's findings are so divorced from the evidence that they are unreliable, then the appeals court must no longer accord that same deference to the judge's inferences and findings. Here, the judge made inconsistent findings regarding the children's bond with the mother, which show a lack of attention to evidence. The judge first made multiple findings about the existence of a bond between the children and mother. Based on the department's own records, the judge found that mother engaged with the children during visitation, which steadily increased to overnight visits through March 2021. These are findings 85 through 92. In addition to the usual visitation, the judge also found that beginning in November 2020, mother participated in early intervention services with both children. And she would join these virtually when she didn't have a visitation or a visit with the children at the time of the early intervention appointment. That was, again, beginning in November 2020. That's finding 76. The judge then inexplicably issued a finding that there was no evidence that mother was appropriately engaged in visits past July 2020. That was finding 113 in conclusion of law 42. The judge therefore drew a line in the sand at July 2020, concluding that there was evidence that mother was engaged with her children before July 2020, but not after July 2020. This line is arbitrary, and it's not based on the evidence, and it's contrary to the judge's earlier findings. The judge's own findings show that mother was so engaged that the visits went so well that they proceeded to overnight visits 8 months after that arbitrary line of July 2020. Even after the department decreased mother's visits to once per week in April 2021, mother continued to attend the vast majority of visits, with the last visit taking place 6 days before trial. This was a paper trial. There was no testimony. There's no evidence. There's no allegations contained in the department's own records suggesting that the quality of mother's visits decreased at any time. The judge lauded the quality of the visits before July 2020. There's no evidence to suggest that the quality declined at any time after July 2020. Where the findings are inconsistent and ignore the evidence, with the judge's line arbitrarily drawn at July 2020, despite evidence to the contrary, this panel should not give deference to the judge's baseless inferences and findings. In addition, the judge compounded her error when she concluded that mother engaged in behaviors, including domestic violence and substance use, that inhibit the formation.
Before you get there, do you have any disagreement with the judge's findings that visits occurred in July of 2021 on July 1, but thereafter they were sporadic?
In July 2021,
I'm looking at finding 95, and it appears that after July of 2021, not July of 2020, a number of visits did not occur, partly due to mom's health, partly due to her hospitalization.
that is correct.
And that at one point, the social worker, as of October, was unable to reach her.
That is correct. For
Is
two
there
visits.
any possibility that this July of 2020 is a typo? I haven't gone back and combed through this carefully enough, but
I do not believe so, but the fact that we would have to guess if it is a typo, to me, says that it's unclear and not consistent with the evidence.
well, let's say we were to agree with you. I'm still looking at the visitation history in 95 through 100. and it is sporadic, and she does have ongoing health problems.
She does have ongoing health problems. Mother was diagnosed with COVID, and she was also hospitalized. She did miss some visits between July 2021 and October 2021. However, she also attended at least 4 visits virtually during that time, showing that she was making effort to attend when she was able.
Yeah, I mean, the judge's finding was that she was unable to form a healthy bond. It wasn't no bond, it was a healthy bond. And into that word healthy, the judge imported the notion of her ongoing struggles with substance abuse. Correct?
I think it's fair to characterize it that way. However, the case law shows over and over again, the court has found that despite a history of substance use and/or domestic violence, a parent can have a significant bond with their child. Here, there's no evidence that mother's behaviors interfered with the bond. There's no evidence that if we take Justice Sullivan's view that the date
I don't
was-
have a view, I just
Okay.
have questions.
If we
Don't assume a view from the questions.
I apologize for that.
No worries.
Whether we're discussing July 2020 or July 2021, whichever date, there's no evidence to show an interruption of the bond between the children. There's no evidence to show that the bond was unhealthy. No expert testified, and it was a misapplication of law, a misunderstanding of law, to assume that for the judge to apply this
See,
law.
we're talking, I mean, the judge made note of the age of the children,
Yes.
3 weeks, the amount of time that the child had spent away. So all of your statements are assuming a bond to begin with.
Yes, and the judge found evidence of a bond leading up to July 2020 in her positive interactions with the children.
Positive, what finding?
85 through 92 show that mother and child were
No, I'm saying
appropriately...
a finding of a bond.
She found it evidence that the mother was engaged, suggesting a bond. The judge ultimately did not find that there was a bond. The judge ultimately found that there was no evidence of a healthy bond between the children. But her findings at 85 through 92 show that mother was appropriately engaged. The evidence also shows that the older child, the son, was showing evidence of a bond, hugging his mother, speaking about his mommy's house in between visits, sitting with his head on her lap. There was evidence of a bond between the child and mother.
But the judge never makes an explicit finding that there was a bond at some point.
No, she does
Simply
not.
that she engaged with the children.
Yes. The judge did, however, make a statement that it was the mother's behaviors that inhibited the bonding. And there's no legal basis for that statement, given the case law. And there's no evidence to support that mother's behaviors, the domestic violence or substance use, inhibited the formation of a bond.
Well, to the extent that those behaviors prevented the visits from happening, would you agree that that would inhibit?
It's unclear from the, yes, if mother was unable to visit because of her behaviors, that could eventually, theoretically, impact bonding. There's no evidence that that occurred here. And the visits that appellees note were missed occurred over the course of less than 4 months in 2021, after mother had been very engaged with her children from the time of removal in January 2020 until July 2021, when visits became less often. Although mother did continue to, after the visits were decreased in April 2021, mother did continue to see the children at the vast majority of visits offered between April and October. I'd like to address the last error before I run out of time. The judge also made a clear error of law when she considered the foster parent's position on visitation. The judge incorrectly applied the two-pronged test set forth in adoption of Ilona. In Ilona, the child was bonded with the biological mother whose rights had been terminated. Ilona's pre-adoptive mother was supportive of continued contact and would continue to allow Ilona to visit with her biological mother. Because of this, the Supreme Judicial Court weighed the benefit of a court order for visitation for Ilona against the rights, or against the intrusion of a court order for visitation upon the rights of a pre-adoptive or adoptive parent. In doing so, the Supreme Judicial Court announced the rule that requires the consideration of the adoptive family in cases where a family is ready to adopt the child. That is not this case. Ilona is markedly different than this case. At the time of trial, the department was in the process of vetting 3 potential kin placements. The foster parents are not pre-adoptive parents, and there's no intent for them to ever become pre-adoptive parents. As a result, the position on visitation is irrelevant. Their actions are controlled by the department, and the children could be moved to another foster placement, thereby rendering the first foster parent's position on visitation meaningless. Instead, the proper inquiry is whether an order for visitation is in the children's best interests. Where the children have a significant bond with mother and visitation is in their best interests, a court order would provide the children with assurance that they will be able to maintain contact with mother. The department mischaracterizes mother's position as requiring an order for visitation in every case where there is no adoptive parent. To the contrary, mother seeks only to have the foster parent's position disregarded and for an order for visitation under the facts of this case. Where the children have a significant bond with mother and the trial judge committed clear errors of law in deciding not to order post-termination and post-adoption visitation, mother respectfully requests that this matter be remanded to the juvenile court for a hearing on post-termination and post-adoption visitation so that the judge may properly review the evidence and consider new evidence. As to any other points I have not addressed today, I rest on my brief.
All right. No further questions. Thank you very much.
Excuse me. May it please the court, Jeremy Bayless for the Department of Children and Families. Post-termination, post-adoption visitation orders are a right that lies with the child. They are put in place in order to facilitate the child's transition on the tortuous path from one home to permanency. They are not a right that lies with the parents. As a result of that, unlike findings of unfitness or the question of termination, there is no presumption in favor of a bond or in favor of a visitation order. Rather, there needs to be affirmative evidence of not just positive contact, Douglas makes that clear, not just visits went well, but of such a significant bond between the parent and the child such that the abrupt severance of that bond is not in the child's best interest. And when the judge was making that decision at trial, the facts that they were facing was that in the months preceding trial, mother had relapsed, she had ceased therapy, she was becoming more sporadic in her attendance at visitation. She still attended visits, but worse, with less frequency than she started. And then at trial, mother doesn't show up, which is really why waiver is probably the most important argument here, is that mother didn't attend trial. She did not show up and she didn't ask for an order of visitation, and therefore, the court took a negative inference from her lack of attendance of trial. So when looking at the question of whether or not these children were so bonded such that a visitation order was in their best interest, part of that best interest analysis is from the view of the court, it's very possible that the mother had fully abandoned the proceedings. And making a visitation order with a parent who doesn't want to attend visits or does not want continued contact with the children, I posit would clearly not be in their best interest. And so that's why there aren't the exceptional circumstances necessary for this court to review an unraised or waived argument below and actually get to the merits of mother's visitation arguments. But even if you're inclined to, the arguments must fail. There's no affirmative evidence that the bond is such that the children, that an order will be in their best interest, that the children will be harmed in any way by the lack of a visitation order. The court's, any error in the court's findings or imprecision in the court's typography is harmless because the evidence is clear and is supported by the record that mother was doing worse at the time of trial and that she was doing so in a way that could potentially have significant impact on the children. Finally, just to briefly touch on the foster parents' position, while foster parents are obviously not entitled to the same level of deference as pre-adoptive or adoptive parents, they don't have those rights, that doesn't preclude the court from considering the facts before it. Had the foster parents been adamantly opposed to visitation, had they, the records indicated that they felt visits were harmful for the children, that would have been information that would have been relevant to whether the court's, not dispositive, but relevant to whether or not a visitation order would be in their best interest. Similarly, if the foster parents are completely fine with facilitating those visits, it makes it easier for contact to happen. It makes it easier for contact to happen without a structured visitation order. It's not dispositive, it's not given the same weight as a pre-adoptive parent, but it certainly is relevant information that the court did not err in considering, and nothing in the court's findings indicate that it was treated with any additional weight or additional legal significance than is appropriate.
But certainly, if the foster parents, for example, had been in favor of such a position, and as in this case, it seems as if they facilitated and were helpful during various times during the course of various visits, how should that have been? How would that inform a judge's decision? Because, as I said, giving it the opposite, let's say they're in favor of it, the foster parent's position is just short term. That's the nature of foster parenthood.
I think it's fair to say that it's, there are significant facts and then there are relevant, less significant facts. Mm-hmm. The department, so long as the children are in the department's permanent custody, is the decider on visitation, barring a court order, obviously. And so we look to the foster parents. They're the ones who have the most contact with the children, consider it. And so the court can consider that, but it's not a significant factor, and it's not to the same extent that an adoptive parent. Did that answer your question? Mm-hmm. So it is a fact to be weighed in the grand scheme of things, but it is not one that I would expect to often tip the scales, if that makes it clearer. And with that, if there are no further questions or other issues, I'll rest on my brief and cede my time to my sister. Thank you.
Thank you very much.
May it please the court, my name is Christina Canoyer, and I represent the appellee children in this matter. And on behalf of the children, I'm asking you to affirm the lower court's judgment in its entirety because the judge clearly did not abuse her discretion in issuing these orders. I'm going to start by following up on the court's last question posed to DCF. The finding about the foster parents does not necessarily support the actual finding of the best interest with respect to visitation. There's a number of legal aspects the court is considering. One of them is reasonable efforts. The fact that DCF put these foster parents and the mother in direct contact, that doesn't happen in every case. So on one hand, it's going to show that if DCF is presumed to act in the children's best interests, that this is one way that they're doing so, and that if they're going to be able to continue to facilitate weekly visitation for mother in the interim while searching for an adoptive family, and this foster family indicated that they were willing to care for the children during that time, that the children would be able to see mom if it was in their best interest without a court order. Now, we don't get to this if the issue has not been preserved for appeal. And mother had a visit with the children in person a week before trial. She did not appear for trial, and the carry suggests that there was a warrant out for her arrest. The judge was able to take a negative inference, finding that if mother were to appear, she would not be able to rebut the allegations made against her. Mother submitted motions in limine, but she did not submit anything requesting any sort of continued contact or visitation post-trial. Mother, after the fact, cannot come before this court and ask this court to review the lower court's decision without pursuing that in the lower court first. Assuming...
Is that...
Yes?
If we're charged, though, with reviewing the best interest of the child, does that waiver rule apply as an absolute bar, or are we looking at this under the extraordinary circumstances test?
Mother has not alleged any extraordinary circumstances for not raising this in the trial court.
I'm not saying it's an absolute bar. You're saying we should approach this with caution.
Yes, there are times when it could be reviewed. In this case, where Mother had the opportunity to present the issue or at least challenge it through counsel in some manner, that's where it would be deemed waived. The judge did consider it, and on notice of the fact that DCF was moving to terminate parental rights, continued contact with any biological family members is something that the judge would consider. So the parties were aware that continued contact would already be at issue. So the children would ask that the court not consider the substantive argument. However, turning to the substantive argument, the only question for the lower court is continued contact in the best interest of the children? That is the first and only question for the judge to consider. That comes from Alona. Alona is a two-pronged test. Mother is getting into, by even talking about the foster parents, is getting into, if so, what orders would be best. However, even in Alona, the judge found that there was a substantial bond and still did not order post-trial contact. And we also see from Rico and Vito that in cases where there's a substantial bond, the judge has the discretion. However, there's no evidence from the record that it would be in the children's best interest to have continued contact with Mother. Bonding is an expert term, but the courts in other cases have recognized the natural bond between parents and children. However, that exists at birth. And the judge did note that that Mother had positive visits with the parents. And Mother had positive visits with the children, I apologize. The judge did not issue orders that are inconsistent. And on that note, the July 2020 versus 2021 issue, the children would argue, is scrivener's error, typographical error. When the order is read in its entirety, you're able to follow the timeline of events. The judge does jump back and forth between dates when talking about the different issues that she was evaluating. But ultimately, July 2020 appears to be the only date issue in there. And even on the judge's first page of her conclusions and findings, the longer second issued order in July, there's a number of dates that are correct. January 21st, 2020, January 24th, 2020, May 25th, 2021 is when the goal was changed. These are a lot of 2s and 0s and 1s. And I think it's reasonable to excuse one typographical error about the July 2020 date when the judge's findings do go on to explain how after July 2021, the visits clearly deteriorated. And on the subject of bonding and attachment, where there's no expert to testify about bonding, it really is the judge looking at the positive attachment and to some extent speculating about what might have inhibited the bond. However, the mother's substance abuse clearly did prevent her from having visits when she needed to be hospitalized for substance abuse treatment, for mental health treatment. And in 2021 is when we see that even though the judge recognized that there had been positive visits up until then and that there was a positive attachment, visits went well, there's no evidence that the children had difficulty separating from Mother or that they had meltdowns outside of visits wanting her. In February and March is when the children had overnights and actually asked for the foster parent instead of mother, and mother ended up calling DCF and ending the visit early. And that was the last overnight that they all had together. From there, the visits sporadically occurred virtually for 2 months, in July and August, I believe. And the children would just ask that you affirm the judgment of the lower court in its entirety, and I will rest on my brief.
Thank you very much. Thank you, all of you, very much for your arguments today, and we always take these cases very seriously. We'll look at it carefully, examine the record, and get back to you as soon as we can. Thank you. That is the last case we have on our list for today. I want to thank everybody very much for participating today, and the court will stand in recess.